stuff like that. But first off, yeah, thanks, Max. I really appreciate you setting me up. It's awesome. Kate for the invite. Kylie, I don't think is here, but poster's rad.
She should be here.
Cool.
Eventually, she'll be here.
Well, thank you, Kylie, either way. Yeah, so I work specifically with the creative community with Aspect Law Group, co-founded it a little over 2 years ago with a lot of designers, development in general, artists somewhat, just because it's like, I'll talk to later, there's some really good resources for visual artists. Because you all make a ton of money, right? So, gotta do something. Yeah, so thanks for coming, I really appreciate it. It's a pretty good turnout. So I hope I'll make it interesting for you. I kind of went overboard on slides a little bit, but I think we'll be okay. Yeah, it should be cool. I got excited. I was like, yeah, let's talk about this and this. But I know we're slotted for like 45 minutes-ish plus questions, so I'll try to keep it within there. Okay, so topics we're going to cover, right? You got to tell people what you're going to talk about. So business stuff, copyright. We're going to talk about collaboration because this town loves collaborating, but it comes with issues. So you just got to know about them, right? It's fine if you know about it. So fair use on that, contracts, and then some general resources. And if we have time, I want to talk about the Visual Artists' Rights Act, because it's pretty cool if you do any sort of like visual art work. But yeah, we'll get there. It's a little less design-oriented, so that's why I put it last. Okay, so business law 101. We'll get a show of hands if you've done any of these things. Have you freelanced before? Have you independent contracted? Have you just like kind of run your own sole proprietor or whatever? Rad. They're all the same thing. So if you do any of these things, you legally are in business for yourself. And that comes with a whole host of legal issues that come along with it. And it's really not the best thing to do here, so we're going to try to clean that up for you. Okay, so business entities in general. The informal kind is what we were talking about before, so like sole proprietorships. If you've just done work on your own, but you haven't like legally set up any sort of business, you are technically on the hook for all of those things that you've done. Same as if you like go into a partnership. So if you're working with somebody and like making work, getting contracts, you are legally in business, regardless of if you think of yourself as like a design agency or not. And if you were to sell your business too, it's all going to be tied to that LLC or corporation. And so if someone came in and was like, I want to take your place, you're like, cool, sounds good. You could just like transfer your ownership over instead of having to do like all these different assignments of different things and selling it out if you didn't have the formal entity. And then it also like clearly sets up expectations and roles. So with corporations, you're going to have a board of directors and officers and shareholders. If you have a small corporate, it could be all the same person too, so it doesn't really matter. You could be the board of director, and you could be the officer, and you could be the only shareholder. LLCs don't have those. But anyway, it's still like a way to kind of separate it out from yourself personally and give you a chance to talk about what you'll be doing in the business. Okay, so I'm going to talk about partnerships. I kind of talked about this already, but yeah, if you just start working together, the issues, then there's like, well, who actually owns what you made? Is it the business? Is it like you two together? Is it just one person? Yeah, then you have personal and joint liability. So if you were to work with somebody and they messed up, you'd be on the hook too. And that's, again, why you want to like separate that out and have an actual business. And then joint authority too is that if you're in a partnership, they can make a decision and it binds both of you. And so you can manage that with contracts if you want to. I would just recommend just going and setting up a formal business entity instead. Okay, so these are like the formal business entities. You got corporations and LLCs. Corporations, again, they have all the separations. They have more formalities that go on, but LLCs don't. But corporations are really good if you want investors, because you can just then give them shares and they'll be just passive investors in your business. But yeah, more formal requirements. You have to have your annual meetings and stuff like that. With an LLCs, there's no annual meetings, there's no board of directors, there's no officers. It's just the owners of the business. So a lot of people prefer LLCs for that reason. You also don't have to have like annual meetings. You probably should be talking to your business partners once in a while, but I guess you don't really have to. Yeah, so less formal requirements too. You can do a lot more with an LLC than you can with a corporation. So typically, that's why people like LLCs a lot. And then you can also, right now there's some like cool tax loopholes, so you can actually tax your LLC like a corporation. And that's some pretty like highbrow stuff that your accountant will handle. But you can take advantage of really good tax loopholes essentially with an LLC, so you get the benefits of both. And with an LLC, you can still have passive investors, but it's a lot less straightforward, a lot more paperwork, and because they essentially are part owners at that point in time, so you have to set it up to where they can't make decisions for your business anymore. Otherwise, if you get into an LLC as like another member, you have voting rights automatically in that business. So it's a lot harder to have someone be in there that does not have voting rights. It's copyright.
What?
Who's trying to copy? I know, right? This is a big one. Okay. So people coming out like pretty often confuse this with trademarks or patents or whatever. A lot of people just use patent to mean like everything. But we're just going to talk about copyrights today. So what is it? Copyright, it's a type of protection for fixed creative works. What that means is like anything that you make that is like tangible, essentially it has a copy. So if it's digital, there's a file, right? There's your copy. If it's a painting, well, there's your copyright. You made that painting, it's physically there. So it has to be fixed like that. It can't just be something, you can't just like get up, like right now what I'm doing. Well, I actually do have copyright because there it is, right? But in my speech right now, I don't because I'm not recording it. And so it happens automatically too. You don't have to do anything to get copyright protection. As soon as you make it, it's there. Yeah, and it's also exclusive to whoever makes it. So if you're the author, right, then that's yours. It's your rights that you get automatically. Registering does have benefits, and I'll talk about that in a second. But yeah, so when you get it, it's actually a bundle of rights. It's not just like one thing. It's several rights that you get as the copyright owner. The main ones pretty much are to make copies, so reproductions, right, to make copies of the things you made, to distribute those and to display them, and then to make derivative works. And derivative works are things that you make based on the original. So if you make a painting and then you, I don't know, make a painting based on that painting, that would count. Or even, this happens a lot kind of in the design field too, if you present some assets to somebody and then they build off of that, that's a derivative work because it incorporates what you've made. And so all of those rights are yours initially, with some exceptions, which I'll talk about too. And it's all technically it's property, so it's all transferable. And since they're individual rights, you can transfer each of those individually. So you don't have to like give someone the right to all of the things, you can just give them specific rights. So oftentimes you'll see the right to reproduce and distribute and display together if you want someone to like produce posters for you, right, and sell those posters for you, because they have to have those rights to make copies of the thing that you made. Yeah, and then you can also, I mean, you can license those out, so you don't have to like sell them ever, but you can, and then you can sell them individually. You can license it, which means like you give people the right to do those things, but you still retain ownership of it. So it's pretty cool. It gets complicated though. And then, so the benefits of registering, so like I said, you don't have to register, but you can, and it's really inexpensive. Filing fees are $35, and if you get into photography, then it gets a little more expensive if you want to register in bulk, which you can. In photography, if you do photography, you can register once a year with everything that you've done. It's a higher filing fee, but it's still like very reasonable. It's fairly straightforward to do. Granted, it's a government website, and they're all really terrible to use. And so if you can just like navigate that, they have a bunch of help videos and stuff on copyright.gov. And so if you can navigate it, I would recommend doing it because the benefits there. Well, if you ever wanted to sue anybody anyway, you have to register first. But then if you register, one of the biggest benefits is called statutory damages. So normally if someone were to like steal your stuff, right, you get what's called actual damages. And that's the amount of money that it would cost that person to license it from you to begin with. And so usually that's not going to be that much. So if you were to make an image and someone used it on a shirt, right, but you didn't give them the rights to do that, and you sued without registering, it'd be like, okay, well, how much would you have originally got to use that image? And then you're getting into licensing rules and royalties, and it's really not that much if you're going to get. But if you register, you get statutory damages, and those set up at a bare minimum of $750, and then go up to like I think $150,000 if it's willful infringement. So if someone purposely stole your stuff, then you get a lot more money. And it's way easier to just point to that and say, I registered, this is how much I get, done. You don't even have to get into the whole thing about, well, how much would it have cost?
Does that mean you have to register it before they steal it?
Yeah, so the way that works is, so if you, when it comes out and it's published, right, you have this window. You have like a 3-month window essentially to register. And if someone takes your stuff in that window, you will still get those rights. But if you miss that window, then yeah, you just have to register at any point in time before they infringe. That's a good question. Oh yeah, if you do this, the turnaround time to get your actual like copyright registration, right now I think it's like 18 months. It's insane. Go Copyright Office. Yeah, but it's retroactive.
So would that be like to register every single image in order to?
If it's in a series, you can do that. If it's like related, you can do just a bulk registration. If they're not, then you are supposed to do them separately. So then on that one, it's just like, what is the risk there when you're putting it out? How much do you really care? If it's something that you really care about, then register that.
So you're like, so like the difference is between like you have automatic copyright because you're just, and so then if you want to take it a step further, then there's registration.
Right. Okay, so we kind of talked about what copyright covered already. It's like artworks, creative things. Copyright does not cover not creative things. So that's like facts. You can't. No one owns facts. Styles. Well, you'd be surprised. Some people are like, I made this up. Or especially when you get in like writing, people are like, oh, those are my facts. No. Styles. So you can't copyright styles. Like it's in the same kind of thing like ideas. You can't protect ideas. You can in a patent sense, like if you come up with this really cool idea of this new thing, you can register that, but you can't like register, general ideas. Scenes affaire, which means just like standard common elements. You see that a lot more in like literary works, but it would still apply here too. So kind of back into the styles sort of thing. Like you can't make certain artwork without using certain elements, if that makes sense. Then anything with utility too. So if you can use it, not going to be copyrightable. It might have elements to it that you can register, but if it has an actual function, you're not going to be able to register that as copyright. And it's interesting because graphic design, the Copyright Office saw that as being utility because it was a way to present information better. So it's useful. They are slowly coming around to it being a creative work. And so if you do try to register graphic design specifically, don't call it graphic design, call it something else, like an artwork, right? If you have a poster that you made or something, don't call it graphic design right now. Give them some more time. Old white guys, you know what I mean? Okay, cool. So everybody always asks about fair use. It's really interesting, I guess. So fair use is this part of the law that allows people to use things that otherwise you'd need to ask permission for. It is not very clearly defined on purpose because they want it to be a case-by-case deal. And so what it is then, it's called an affirmative defense. And if you have to use an affirmative defense, it means you have already been sued. So that's what fair use, that's when you get to prove fair use, is once you're actually in court. Thankfully, there's a new case that came out that said if you get a DMCA takedown notice, so it's like, I don't know if you've heard about those, but YouTube put something up, someone's like, that's infringing. They have to at least think about whether or not it's fair use first. And then if they don't do that, and you can prove that they don't, which is really hard, then you get a bunch of money from them. Pretty cool, I guess. And so yeah, it's affirmative defense, there's no clear lines, and pretty much what they set out are these factors that you have to consider, and it's kind of this balancing test overall, and it's the purpose of the use. So what are you doing with the new work that you've made based on someone else's work? And then what were they doing originally too? And you got to see if it overlaps at all. Then you got the nature of the copyrighted work. So if it's more creative, it's going to have more protection. And then also, like, if you are more creative with what you've done, then you'll have a better case for fair use. Then the amount that you use too is considered. So if you're taking the original work and using that, then that's going to weigh against you. If you're just using parts of it, then it's better. And then the effect on the market is a pretty huge one too that courts look at a lot. So if you make something and it's interfering with the other person's ability to exploit their work, like if they're losing money because of the thing that you've made, that usually ends up being a pretty big one. And so you kind of look at all those things and you go, oh yeah, okay, it's fair use. And we're going to talk about some fair use cases. There's some of my favorite ones. But an alternative to this too is you can just get a license to do these things, especially if it's someone that you just like, and you can like reach out via all these social media platforms now and just say, hey, do you mind if I use this thing that you did for this other thing? If they say yes back, cool, that's a license, you're good to go. Even in an email, you can just have, like, shoot an email out, and if you have that email again, that's good, it counts. It doesn't have to be like a formal license. Granted, I mean, if you're trying to use like Marvel Comics or something like that, don't expect to hear back. Although maybe, if you have a really good idea, be happy to help you with that licensing. Okay, so yeah, let's talk more about fair use, right? Because it's this really weird concept. I have a feeling like people. Do you want to hear about fair use? Is that? Yeah, I feel like that's probably pretty relevant, right? Cool. I had this morning, so I'm pretty excited. Okay, cool. So this one's really interesting. It's Roth greeting cards for United Card Co. And it's in the Ninth Circuit, so that's what we're in right now. And so it's only applicable to our section, but that's still, I mean, it's relevant because we're here. And it made this like really interesting new law. It's called like the total concept and field test. And so what happened here is on the left, we got this card company that's making these kind of like simple cards, and they have these, I barely read them, phrases in there that is kind of like kitschy phrases. Your absence is raising hell in my sex life. So, yeah, and so it's interesting on these because like the court noted, right, that you can't protect short phrases. Those are just like, assumed to be kind of like fact-based or whatever. And so this other card company wanted to essentially compete with this other company. And so they made cards that are extremely similar, but they're not the same, right? They just have these elements that are very similar. They use the same phrase, color schemes, sort of. And the court found for infringement. And partly it was because evidence came out that said like they knew that they wanted to compete, and they took all of these cards and specifically tried to make cards based on that derivative work, potentially, right? And so court then goes, all right, we know that you had access because proving copyright infringement takes access. You have to know about other people's works. I guess I should have said that too. You can have independent copyright creation. So if you make the same thing as someone else, but you never knew about the other thing that they made, you both get copyright protection. In practice, I've never seen a case where that happened, but it's theoretically possible. Yeah, so the court's like, all right, you clearly had access, and you based your thing on this, and all these pieces together have the same concept and feel. And so they found infringement for it, which is fascinating because I don't know that that's the right answer to this one.
So do you think that they wouldn't have found infringement if they had just used the words and not the style? Do you think it was just too many things?
It was definitely too many things.
Too many things, but they could have totally taken the words, the copy.
Absolutely.
Okay.
Yeah.
So it's about knowing how far you can.
There's no answer to that. Yeah, and so we're going to look at a few, and you'll come to your own conclusion maybe. So I still can't tell. If I look at you, if you come to me, I'm like, yeah, I feel like it's probably this, but you never know because these kind of things exist. But it's interesting too because typeface is not protected by copyright either. So because they're utilitarian, you can read them. So yeah, I mean, the words definitely not. You could even use the same typeface and it'd be fine. But it was just the combination of all the elements. They said no. And so then we get into another one, Rogers v. Coons. So we have this photographer that takes these kind of pictures, and then Coons makes these statues. And court again, he claims it's parody for fair use. Court says no, because they're too similar. If you look at him, it's the exact same thing. And the court also says he could have used something more generic. You could have like looked at that picture, but then maybe made a statue kind of like it, but not use the exact same, I don't know, sitting the exact same amount of puppies looking the same way. And then I think the court was also kind of swayed because Coons made a ton of money off the statues, and they don't like that very much. So that's another interesting one too. I mean, I think that if you had a better artist statement than just parody, then you could have probably gotten rid of it.
So to say that it's parody, does someone have to decide that it's funny enough? Or like, yeah,
exactly, right? I mean, yeah, you get like experts in to talk about art and really highbrow stuff. Yeah, and so it's kind of interesting too because a lot of judges don't want to seem dumb, and they want to seem like very very cultured, and so they'll kind of accept it. I've seen cases that I thought for sure there's no way it's gonna be fair use, and they're like, fair use. It was just because the artist had this really really good statement about what it all meant and why it was different. So yeah, you can get away with stuff if you have a great artist statement.
So you think Coons just made too much money and had a really lousy justification?
Yeah, that's what I think.
Come on, Justin.
Yeah. Okay, and here's one that where fair use was actually found. Sort of, I guess. It's Grover v. Prince. Prince is an appropriation artist, and so he used these pictures taken of Rastafarians and made new artwork. He actually made like 30 pieces or something like that. And the court found that most of them, so on the left you have one that's it's very different, right? A lot of the pictures just kind of look like this originally. And so that one's very different. And the court was like, yeah, absolutely, it's totally different market, totally new meaning. But they say they weren't too sure about ones like this, where it's just a little bit, they changed it just a little bit. And so the court, they didn't say fully that they don't believe it was not fair use. They just sent it back to the lower court and said, you guys decide. And then just settled, so we don't have actually a clear answer to that. I would say no, though, on this one, because it's just not enough. Using the whole thing, he's just kind of done a little bit. But then again, good artist statement. Might get you past it. Cool, right? So then can you actually use anything without asking for fair using? Answer is yeah. Not a whole bunch of stuff, but you can. Anything in the public domain is going to be totally fine. Typically, that's anything pre-1923. Be careful, though, because if you just get on the internet and start searching images, those might be covered by contracts instead. So you could still be using stuff illegally. It just won't be based on copyright. And so what a lot of people do instead, if you want those kind of works, go to a library, and you can just scan books and stuff like that. Should be good to go. And then 23 to 89, it really depends on formalities. Check this out if you want to see like a whole list of what the formalities were. So if you want to use something in that time period, you kind of have to do some research about what notices were they putting on it, did they actually register, did they not? It all affects that because prior to that time period, it wasn't automatic copyright like it is now. And then foreign works, if you're trying to use that, it gets really complicated. You kind of have to like look when it was here, and then okay, if it needs this right time, then you go back and look at their country and see if it was protected at that time too. It's kind of a mess, but the answer still is yes, you can. Good.
When you register something, is there like a certain amount of time that it's registered for? Is it like forever?
Yeah, but it's after you die is when it ends, so you're good. It's life plus 70. Well, it's automatically. You don't even have to register for that. That's just as soon as you make it, it's your whole life plus 70 years. Which I guess I'll know on that one too. If you were to assign your rights over in copyright, which means like selling it, right? You're selling all of your rights, so you don't own that anymore. you can actually get that back. There's this window, I think it's like a year-long window. After 35 years, you have this window where you just notify them that you're taking it back and you're good to go. And so actually, like a lot of companies now, you'll see kind of indefinite licensing happening a lot. And so that's so that they never have to give it back to you, because you've given like rights to it forever, essentially, but they don't own it. Okay. All right, so collaboration, yay. I hope Joby's watching this one. I love this. Cool, so collaboration, it's awesome. So it's whenever you're working with somebody, right, just be careful. It's not bad, it's just be careful. So collaboration issues, one is a partnership, right? Did you actually start a business because you're collaborating? I don't know, maybe. Kind of depends on what you're all doing, and you can clarify that in the beginning that you're not starting a business, so do that. But joint authorship is what happens if you're working with somebody and you both put something into a work. So it's supposed to be a final piece. It's separate contributions to a single work. And that creates joint authorship. And what that means is that you are both, oh, and also it doesn't matter how much, right? So if someone puts 1 or 2% of the total thing together, then they're going to be co-owners with you, 100% co-owners. You're all going to have the exact same rights in copyright. And the issues with that then is that you can't prevent them from utilizing those rights. So if they go off and tell somebody that they can, make copies or whatever, you can't stop them from doing that because they have those rights. You do too, but as do they. And so the only thing you can't do in a joint authorship is step on someone else's, your co-owner's rights. So you can't sell off all the rights to that, but you can absolutely license them off. And then so that becomes an issue with promises and contracts, right? So if you are hired to then give work product to somebody and they want to own it afterwards, you can't promise them that they will own that work 100% unless you have a writing that says that you own it all, because otherwise the other person still has rights. So you can't actually promise those things. So a good example there, I just thought that's like, if you're an illustrator, right, and you hook up with an animator to make a commercial, if you don't have the right paperwork that says who owns the whole thing, you both own it. And so whoever's in the contract probably can't say 100% that they can give all the rights away. And so the way you get around that was just like managing the contracts. Just get a contractor agreement or even just a simple assignment. And you can search on the internet for assignment language. It's really easy. It's like maybe just a few sentences. And that essentially says that the person that you're working with is going to give you all the rights when you're done. And then you can also set, if you don't want to do that, if you don't have a full assignment, you can just set up whose rights, who gets what with a co-author agreement. So maybe it's like, yeah, it's fine for you to display it or whatever, put it on your website, do whatever you want, but just don't do these other things. But you can also tackle that in a license back. So if you own everything, then you can say, all right, I own it all, but I'm going to give you these rights so that you can still, portfolio rights or whatever.
So, Jane, talking about portfolio rights, if you're working with someone else, what do you have to do to make sure that you can put it on your site as a portfolio or use it as in your portfolio? Do you have to do that?
So it depends on if you're the owner of the work or not. Let's just assume that you're not the owner, or a more traditional, like if you do a lot of contracts, if you get hired to make something, typically the client's going to want to own what you make. And that's fine. Just have in there, it's called like a license back. And then you get a license to then use whatever you made for the client, but only in relation to like promotion for your business. So it'd be like on my website for the promotion of my business. And then you also want to get a license to use their name and maybe logo too in connection with that, because you want to say like who you made it for, right? Which you might not really be able to do if you just get a license to use the work that you made. Cool, so contracts. A contract is any agreement between people, between parties. It doesn't have to be written, it can just be like, a handshake or whatever, or you talk about it in person. That counts as a contract. It's better to be written. I mean, even like an email chain counts as a contract. Just as long as you've agreed somehow to do some things. Contract. It's legal terms right there. Yeah, so they're great. I love them. Please use them. If you do just like an oral agreement, which is just like talking to somebody, there's nothing to go back to if there's a dispute. And so if you have something that's written, you have something to go back to, even if it's like terrible. It doesn't really explain much. It's something. It's better than nothing. And then it's also a great way to set expectations and discuss issues to begin with. So someone hands you a contract, the whole thing's like negotiable. So you should be talking about what you'll actually be doing. What are you going to be providing? What's maximum time limits, right? Maximum revisions. All of those things that you should talk about those so that you can be on the same page when you actually start doing the work. Another part's like kind of on the look, but it just looks really professional to use contracts too, especially if they're like branded contracts. You know, it looks really good. Just good for your brand in general. And then, yeah, like I said, you can refer to it later. Okay, and then less generally too. So back to kind of copyright stuff. Copyright can only be transferred. So ownership of copyright can only be transferred in written instruments. So any sort of like written agreement thing is the only way, for the most part, that you can transfer copyright. Work made for hires is a way sort of around that. So if you're an employee, you don't have to have a written agreement. Your employer just is going to own whatever you make, as long as it's within the scope of your employment. So they're not going to own like what you make at home, but anything that you make for your employer, they're going to own that, and you don't have to have a written agreement for that. But everything else, you do have to have written. And then you see like work made for hire stuff all the time in written agreements. Most of the time, it's totally wrong, because it's work made for hire relates to like really specific things. It's maybe like 8 bullet points. It's like audio visual works is one of them. Atlas is one of them. Collective works is another one. So it's like putting a bunch of stuff in a book. And even with those, if you fall into that category, you still need a written instrument anyway. So you have to have, for the most part, something in writing to transfer copyright ownership, which is pretty cool, because if you have a contract that never said anything about copyright ownership, you probably are still an owner, even though you give it to your client to use. Like what you've done there, essentially, it's called an implied license. And so you've told them, right, that you're going to deliver this thing to be in a magazine. Just because they don't own it, essentially, it's understood that they have rights to then make copies and do anything that was within kind of the original scope. But if they get outside, you can make them stop because you still own it. Cool, I'm passing through this. Well, I guess not really. So, resources in town, this is a really good one. I think a lot of people are kind of scared of attorneys in general, and that's fine. I don't really like a lot of them too, but we're not all bad though. So the Lewis and Clark Small Business Legal Clinic, I highly recommend looking into this if you have your own business, but you're not making a lot of money or anything like that. They also work a lot with women-owned business and minority-owned businesses. And what they do is they have 2 programs. One's the pro bono attorney program, and so they just link you up with someone in town to help you out with whatever you need for that time. And then they also have this kind of more ongoing thing where you work with students from Lewis and Clark Law School. And last time I checked, I think to get in, it's $35, and that's all you pay. So you can pay $35, and they'll set up your whole business for you. They'll, sorry to clients in here. I'm just kidding. Or like if they'll make contracts for you, anything like that. So they're great. The issue with them is it just takes a long time to get those things. And so if you're looking to move pretty quick, it's maybe not the best. But still, I mean, look into it. It's a great resource. Same with Oregon Volunteer Lawyers for the Arts. They do pretty similar things, except they have the scope of the attorneys that work with them it's much more focused for the arts. So I'm a volunteer attorney with both of those organizations. They're pretty awesome. So you might end up working with me anyway. Also local attorneys. So a lot of attorneys in town don't charge for consultations, or will meet up with you for coffee or something like that if you're interested. So don't be afraid to just reach out if you have like a simple question. They'll tell you if you're trying to get like legal advice, they'll tell you, I can't tell you that because it's legal advice, you're not a client. But I'll always point people in the right direction, say, yeah, here's some resources, check these out. If you still have questions, just let me know. So yeah, don't be afraid of attorneys, I guess, unless they're trying to sue you. And then contract generators, I have mixed feelings about them. They can't, tell you to go use them as an attorney, right? But the point here is that they will produce something for you. But just make sure you read it. You really need to understand what you're getting yourself into. So if you get a contract, don't just use it for everything unless you understand what all the pieces are. I've given talks on just contracts alone where it's like an hour and a half that will go through all the different pieces. So they're really complicated. And so if you don't know what you're getting yourself into in a contract generator, you could be in a bad spot. You could have done like assigned rights that you didn't mean to, or made promises that you didn't mean to. So yeah, grain of salt on that one. And then, hey, we made it. Visual Artists' Rights Act. So Visual Artists' Rights Act is pretty interesting. It's a relatively new-ish law, and it applies to paintings and drawings, prints, sculptures, photographic images produced, and the key word here is for exhibition only. And so if you're doing something for an art show, right, or you've made a sculpture that's going to be out in the park or something like that, that'll be covered. It has to be for the original only, though, so it doesn't apply to reproductions. It has to be the originals. But you can do them in limited editions. So if you do prints, right, you can do a limited edition. It just has to be under 200 copies. And if you do those two, you have to sign and number each one. And then it will apply. And so what this does is it gives you these rights. It's like moral rights. So the United States is one of the only countries that doesn't have some stuff that a lot of other countries have, like moral rights. And those rights are to claim authorship. So if someone is putting the work up, right, but not crediting you for that, if you fall under this category, you can force them to credit you as the author of the thing. Likewise, you can force them to take it down, take your name down, if you don't want to be credited. Yeah, and it's like, so you can prevent your name being on things that you didn't create too. Yeah, then if they make any changes to your work too, you can take it down. You can prevent them from making distortions or mutilations or modifications, which pretty much means all the same thing. But this is just kind of like a brief overview, because these exclusive rights towards the bottom, they have a lot of caveats. The one that applies to everything now is the authorship parts. So it's pretty cool. So if you're making visual arts, these are really good rights to know about. And I'm at 45 minutes, so thank you very much. Thanks for coming. That's cool. Yeah, take questions if you have any. If not, then just thanks for coming. It's cool. Have a good
I
time.
bet we've got questions.
Yeah, let's go.
We've got questions.
I make some things that I'll end up reproducing, and I've seen some things already online that are really close to a copy of it, physical objects. What are the rights I can put online?
What kind of physical object is
I
it?
make leather goods, so I have a certain
Okay.
wallet that's really specific.
Mhm.
I'm starting to see that other places.
So that gets into kind of product design, and when I mentioned like the United States doesn't protect certain things, that's one of the things that doesn't specifically protect. So it's this combination then of copyright, trademark, and patents. It would be design patents on that one. I assume you probably don't want to patent anything because it's kind of expensive. So it'd be like essentially looking at copyrights on that one. And then so at that point you have to think about what is the new created part that you've made. Does it have utility? If it does, it's not going to be protected. If it's just kind of more like artistic or design oriented, then maybe it'd be protected. And if that's true, like I don't have the thing here, so I can't really tell you. But if you do have that, then you have the rights to prevent someone else from doing those things. But my experience with kind of fashion and product design is it's pretty rare. If you do have protection, it's going to be really limited to that specific thing that you've done to it. Yeah. You can kind of get around that too with just like branding too. So that happened a lot in like late 90s and stuff. You started seeing just everything patterned with logos. And it is a way to protect the stuff that was going out. Yeah, so you're following on like pattern design and trademarks too.
Do email, like email contracts and things, when there's a dispute, do those become like evidence that you have to work with?
Yeah, for sure.
So people will like bring you like post-it note contracts, like what's the kind, like what kind of stuff do you end up looking at in terms of like laws and contracts?
Like when things have gone bad?
Yeah.
Oh, yeah. I'm dealing with some of that right now. So headache. Thanks a lot. No, so the biggest point to me is if just stay within the scope of work. Whatever you've told somebody that you're going to do, don't give them more than that unless you talk about it and they pay you more or whatever. or get a new contract in place. Because as soon as you start getting outside the scope, it's still providing work, and you don't say anything, then it becomes like, well, what is the scope of work anymore? Like, what are you required to do? And let's say something goes bad at that point. Are you still obligated to perform, even though it's outside the scope of the original work? The answer is probably, if you kept doing it. So that happens a lot, and especially in the email chain contracts, they're usually so vague. But I mean, if you really, really spell it out in email, you should be fine. So like, only these things, provide this much, this rate or whatever, and you'll pay me this time. Yeah. And does that answer your question?
Yeah,
Okay.
So you give a client a contract and you ask for 50% down,
Mhm.
and they pay you, but never, that 50%, but never sign the contract. Does that payment serve as like a binding?
Yeah, that one's tough. So if you start then going forward and acting like the agreement was signed, then yeah, it'll count. But just the payment alone is not going to be like the binding part of it. It has to be payment, and then you start delivering something, you start accepting stuff, and then it's kind of assumed that you're working with the contract. You don't want to be there proving that it's horrible, but technically, you could argue that they did accept the contract.
They should sign the same contract.
Yeah, don't do.
Yeah.
Try not to do. Well, I guess I can say don't, because then things move fast. But try not to do work until you have something in place, because then it's this ongoing thing. And I've been in situations where I'm helping somebody that didn't have something in place, but they promised that they would deliver something. Client just keeps rejecting it, and so the question is, are they bound to satisfy this client, no matter how long it takes? Maybe, yeah, that might happen.
But if you were specific in your contract about how many revisions they would get,
Oh yeah.
then
Just walk away, deal with it. Yeah.
Yeah, which I'm a big fan of doing that.
Yeah,
I
definitely.
just responded to an email. I'm sorry, Brian, but it was someone who wanted to go beyond my 2 revisions that I wanted. I was
Pay
like,
up.
done.
Yeah, or just walk away.
Yeah.
Right. Yeah, totally.
But I mean, I think that's a big ass saver too, when you're like very specific about.
Yeah.
But that's also, I think, the more you do work, the more familiar you're going to be with your own process too, and you're going to know if you can do something in 2 rounds or if you can do something in 4 rounds. So it's just it's kind of about getting to know how you work better too as you do more work.
Yeah, and you can put other things in your contracts too about when you can leave the agreement. So if you get into this black hole or spiral, maybe downward spiral, then rejecting everything, you could put something in your contract that says that you can terminate if you just can't work with them anymore, things like that.
Which is going to be a new addition to my contract.
It's the good stuff.
There
Yeah.
are some projects that just go on forever,
Yeah.
and you want to be done with it. So if this project doesn't finish by X date, you can walk away.
Yep.
I
Totally.
think Alex knows what I'm talking about right now. He's heard me bitch about this project that never ends.
You talked about the more intricate an artwork, the easier it is to protect. So my guess this is a general question about protecting individual art versus a style. Like a style is not a copyrightable thing, correct?
Right. It gets into kind of like really theoretical conversations because while the style is not protectable, the actual expression, like what you did with that style, that is protected. So if someone is copying something that you did, and you're like, that's my style, you'd have to really look at, did they actually take those lines that you did? Did they actually take really specific elements? And that one's interesting. I'm actually working on a case right now where the other side did not take really, maybe like one line they actually took, but the rest they did change it. But overall, it goes back in like the raw 3D cards. It's like we can show access. We know that they had the stuff, and overall they look really similar, and they've used kind of really similar elements. And while I don't personally think that the raw outcome was the right way to go about it, that's still law.
People say there's a certain percentage you can change something.
That's not a thing.
Where did that come from?
Yeah.
I feel like
There's
that's
so many crazy
so
things,
funny,
yeah.
just like before.
It's like so ubiquitous, everyone.
Yeah.
Yeah, it's like, oh, you change, 30%, you're good. Like,
No.
like where did that come from?
Yeah. I don't know. I mean, that's around still.
Tell me where that rumor came from.
It's, for a little while in the music part of it, you could use, there was a few chords that were like, yeah, 5 seconds or 10 seconds or whatever is fine. And then you could probably get a percentage out of that, and then maybe you could apply that to other things, but that's just not how that works.
because I think music is real interesting too. And
Yeah, it's fun.
is that, I feel like that just recently, who is it that's suing Led Zeppelin? Because it's,
Oh, yeah.
yeah,
Right.
right?
I'm surprised I took that one.
I know, but that's the thing now too, I feel like, of course, the internet didn't exist. And I think now with the internet,
right.
we're so quick to be like, to call like, oh, hey, ripping this person off, that person, and so I feel like when Stairway to Heaven came out, like, Twitter didn't exist.
Yeah.
But I think that's, I don't know, it's kind of interesting. I'm curious to see what's going to happen with that case, because do you know so it was like a band that Led Zeppelin opened for when in the very, very early days, like they have, what was the name of this band too? I mean, obviously it did not get to Led Zeppelin status, but it was very, very clear lift of the opening few bars of Stairway to Heaven came from this band that Led Zeppelin opened for. And there's actually a really good thing on, it was a show on NPR like 2 weekends ago that actually talked about that case, and then also talked about a lot of Bob Dylan stuff, and then talked about, it was a lot of like musical copyright. It was kind of fascinating too, because then it's like a lot of the stuff just kind of becomes a part of the cultural zeitgeist that's like, you don't really know that you are being influenced by it, because it's everywhere. And so that gets really like I didn't mean to copy this, it's everywhere, and it's like in my blood, and it just came out, and so, I don't know, it's just, it gets so fuzzy.
My recommendation on that one is to just say you're inspired by things, but it's not based on it. Inspired is okay, based on it's bad.
That's the legal line? Okay.
Well, it's based on it's a derivative work. Yeah, maybe. Just inspired by.
So, okay, go ahead. You have a question.
Yeah, so for portfolios, a couple of the projects we do, we use like real publications, the Mercury newspapers.
Yeah.
Modifying like the cover, but still using the same branding for like self-promoting piece, not a selling piece.
I actually had a bullet point in my slide that I totally skipped over. Personal use. So the United States does not have an actual exception for personal use, but it's understood to be a thing. Kind of falls within fair use. And so that's like, yeah, if you're making something, you can do whatever you want for the most part at home with anything that you want. You can make copies all day long. And I would say that applies to the educational system as well. So portfolio stuff, I think you could probably, well, it wouldn't be copyright infringement, right? Because it'd fall into this personal use exception. It's just if you start selling it, now that's an issue. If it starts, becoming like really, really prevalent on the market, just like if you're online a lot with the thing, then maybe that's an issue then too. But just making like limited runs for showing how you work is fine.
If there's like no exchange of money, then can there still be an implied contract? Like I'm just thinking about for internships, like for instance, if you never sign something where you're officially an employee and you're not on payroll or whatever, and then you make work and you never have a contract, like do you still have partial ownership of that work, or is it implied that like as an intern you're pretty much giving it all of it?
That one is interesting because I personally don't think unpaid internships are a real thing.
They are a real thing.
I mean, I know
they shouldn't be.
It's illegal. I could talk about it for a while. But so with internships, I'll just start there too. This is PSA internships. If you are in a position that you're providing work for somebody and you are taking the place of an employee and they're not paying you, then they're breaking the law. They should be paying you as an employee because you're acting as an employee and they're using your work. So a real unpaid internship where you can make stuff or whatever, but they don't have to pay you, has to be essentially purely educational, and they can't use your work. Like shadowing counts. Just if they're like helping you out, kind of guiding you, fine. But as soon as they start using your work, that's bad. But on your note, oh yeah, totally. Yeah, back wage is easy.
You didn't have a good.
Yeah, so like the labor watchdog in Oregon actually cracked down on that pretty recently. We hit a couple of high targets. So it kind of scared some people. Yeah, it's good for sure.
How can that stuff be shut down more often though? Because you wouldn't believe the amount of emails that I get from
Yeah.
people that are just like, it's a great opportunity, portfolio builder, 20 plus hours a week, unpaid, have to pay for school credit, blah, 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 blah,
Right,
no
right.
supervision, doing all the work. Spread the word.
Yeah.
And it's just like, F you know? And it's
Yeah.
just, I don't understand how that not only exists, but it's like wildly like prevalent.
Yeah. I'm hoping that we'll see less of that as Portland grows, but I
Yeah.
think for a long time, Portland's really small. So
Yeah.
if you were to super back wages, right? I mean, now you're that person that super back wages, and people know each other here, right? And so people talk. So it's kind of, I think for the most part, you just move on. But stopping it is interesting. Maybe you could do that. Pay them.
I've got a really nasty canned email that
Nice. Yeah.
So-
Yeah. But then I guess to answer your
Yeah.
question, you're still the owner because you weren't an employee. And if they want to say that they're the owner, then it's like, cool, you can pay me for all the time that I spent doing these things. Otherwise, yeah, it's still yours.
Do you think when it comes to confronting a person about work that has literally been like, this is my piece of work, my illustration, my painting, someone is clearly using it on their like Magic the Gathering cards or whatever, I don't know. Just an example, I don't know.
That's a great example.
Is it if you email them and you have no response, you continue to email them, is engaging a lawyer really about the tenacity of that person's ability? Like, I'm hiring you to be tenacious to deal with this? Or do you believe that a person can just be as tenacious and get the same thing done?
Sure. Yeah, and actually, it's kind of rare that I jump straight to like really pushing from me. It's usually we talk about the issue first. I kind of provide you with the ammunition that you need to kind of handle it yourself. Because if you lawyer up and send a cease and desist first, they're very likely going to lawyer up as well and respond back. And so if you can settle it first without getting to that level, it's going to just be a lot cheaper and people are going to be a lot nicer about the whole thing.
You can't get them to respond.
Yeah, so there's routes. I mean, Wizards of the Coast, right? That's who does.
Yes.
They probably respond. But if they don't respond, it depends. If it's if they're making physical things, you could potentially shut it down through their publisher. If it's online, it's really easy to shut stuff down through the DMCA, Digital Millennium Copyright Act. You can do these takedown procedures, and that's kind of like this 5-point thing that you're like, here's my work, here's their work. I believe it's infringing. Just a couple of things. And then you send it out, and really big companies like YouTube and like Amazon have that process embedded in their sites, and so it's really straightforward. And then it just takes it down. The other thing, they have the opportunity to respond, but if they know they're infringing, it's a really bad idea to respond to that. So it's free to do that.
Etsy's also they just launched something like 2 days ago. They posted something about this also.
They've had a DMCA process for a long time. I think that they are trying to make it a lot more transparent and a lot more accessible because it's like legal jargon essentially that you have to read.
They
but
make a cute
Etsy
video
is
about it.
rampant with copyright infringement. It is crazy.
Yeah, it's insane.
Yeah.
But then you go over from like the smaller shops to like the larger corporations that just kind of, I think right now I think of like Urban Outfitters that it's just been years and years and years and years of and I think it's really hard for people that feel like they're kind of helpless to go up against a machine that's like that too.
Yeah.
And then also too, when you're talking about, I've had a bunch of my stuff ripped off, but it's been in China. And so you're just like, oh, well, shit, never mind, because you don't even know where to begin with that. You just think it's kind of funny. Like, I mean, it's a weird.
Right. Yeah. China's IP laws are strange.
Yeah.
But then again, I mean, they still often use the same like U.S.-based servers for stuff like Big Cartel. I was recently able to shut someone down that was in Australia because they used Big Cartel. Big Cartel's here. So, gotcha. Yeah, so sometimes you have outlets. Usually it's like you just black out their internet presence. But the physical goods still exist.
Yeah. Brian, this is awesome. Thank you.
Yeah, thanks for inviting me.
person
Okay.
and